Welcome to this licensing hearing. The first item on the agenda is the election of a chair, and I understand members would like Councillor Looker to chair the hearing. Is that agreed, members? Thank you. I'll hand over to the chair.
Thank you very much, Fiona, and welcome everybody to our remote hearing of this licensing application. I think a number of you are very familiar with how it all works, but I will try and take us through it gently and sensibly as we go. I would say, though, that if you are not speaking, it's probably helpful if you are muted, because, as you appreciate, it often creates interference, and I often get to the passage of cats going through my dining room, so that is noisy. So we will mute unless we are called to speak, or you wish to signal that you wish to speak. So I'll make the introductions. I'm Councillor Janet Looker. I've got Councillor Ashley Mason, who is also on one of the members, and I've got Councillor Ian Cuthbertson, who is the other councillor who is hearing this application. We have three officers, Leslie Cook, who is the licensing officer and will present the report. We have Fiona Young, who is managing our lives for us. And we have Sandra Brannigan, who is our legal representative, and she will be advising us on the law as we go along. So I've got an applicant. Would you like to indicate yourself?
Good morning. My name is Leo Cherilambides. I'm the barrister representing the applicant, and the applicant himself is Ben Williams, whose face you can see on the screen. So it's just the two of us today.
Thank you very much indeed. We have three people. There have been quite a lot of representations around this application, and we've got three people here to speak on behalf of those representors. There's Rosie Pressland, if you'd like to wave at us, Norma Rees, and Ian Cyril. So yeah, you will get called upon at the appropriate times. Now, can I just ask any of the members if they have any declarations of interest to declare on this particular application? I have none, indicating none from my fellow colleagues. We need to take a resolution because this is being live streamed. We will need to make a resolution that when we go into session to make a determination of the application, that we will at that point exclude the press and the public. Do my fellow members agree that we should pass that resolution? You can wave your hands, that will do very nicely. Thank you very much. Now, I hope everybody's had, I do not need to ask our learned friend, but I hope everybody else has had a detail of the process that we follow, and I shall take us all through it very carefully, but I hope swiftly, so that we can make good progress. I will call upon people when it's their turn to speak or ask questions, and I'm sure we will all manage absolutely beautiful. Before we actually start, has anybody any question they would like to raise as to how we're going to proceed? If so, just unmute yourself and speak. Okay, we will press on then. Leslie, you're first up as the licensing manager making your report on the application.
Thank you, Chair. Good morning, everybody. So this is an application for the grant of a premise licence for the liquor store, the Chocolate Works, Bishopthorpe Road, York. This is one of the original buildings on the old Terry's chocolate factory site. The licensable activities applied for are the supply of alcohol on and off the premises, Sunday to Thursday from 9 a.m. until 11 p.m. and Friday and Saturday 9 a.m. until midnight, and New Year's Eve until 1 a.m. I must apologise that there is an error in the report. It doesn't say that it's also for off sales. Oh, sorry, it doesn't say it's also for on sales. It only says off sales. The opening hours are Sunday to Thursday 9 a.m. until 11:30 p.m. and Friday and Saturday 9 a.m. until midnight 30, and New Year's Eve until 1:30. Again, I apologise that New Year's Eve was not mentioned in the report with regards to opening hours. Following negotiations with responsible authorities, the applicant has removed the request for live and recorded music from the application. They have also agreed that they will only sell alcohol as an off sale until 2300 hours or 11 p.m. each day. A full copy of the application and the plan can be found at Annex 1. The premises is described in the application as a self-contained building on the lower ground floor. It will be a cafe, deli, wine bar, restaurant with an on and off sales of alcohol, mainly for the use of local residents. An overview of the circumstances in which entertainment activities are not licensable can be found at Annex 2. As part of the application, the operating schedule submitted by the applicant showing how the licensing objective would be met can be found at paragraphs 10 to 14 on pages 8 and 9 of the report. I can confirm that this premises is not located within the Community Impact Assessment area and that the consultation process was carried out correctly. North Yorkshire Police have mediated with the applicant, who have agreed to modify their operating schedule to add additional conditions. The agreed conditions can be found at Annex 3. There are 41 representations from other parties. The list of representatives can be found at Annex 4. 30 of these representations are objecting to the application and 11 are in support. The representation 41 was signed by 52 local residents. The representations can be found in full at Annex 5. A map showing the general area around the premises can be found at Annex 6. The committee has the following options when making your decision. Option 1, grant the licence in the terms applied for. Option 2, grant the licence with modified additional conditions imposed by the licensing committee. Option 3, grant the licence to exclude any of the licensable activities to which the application relates and modify or add conditions accordingly. Option 4, reject the application. An agenda supplement has been published since the initial report was published with additional information from some representatives. That is a brief overview of the report, Chair.
Thank you very much indeed. Now, the next item is questions. Sorry.
Sorry, I was going to ask if there was a questions because I needed some clarification. So I was jumping ahead.
I'm doing the, you are jumping ahead of yourself. We are going to do questions for the licensing manager. That is very different from your representation. It is questions for clarification or just making sure that we all understand exactly what is being applied for. So, yes, Mr. Charalambidis, would you like to ask?
Thank you very much, Mum. Leslie, sorry, very briefly, the off sales amendment that was made with public health, you said from 9 to 2300 hours. As I understand it, the off sales are from 9 to 11 a.m. So you're able to purchase your off sales from 9 till 11, but not after 11. Is that right?
That is correct. Sorry, Leo. I've read the 11 in the report, and because I've written so many 2300 hours above, I've put the incorrect. You are correct. Yeah, 9 a.m. till 11 a.m. the off sales of alcohol. And
that is by way of discussion with public health. Is that right?
All I can confirm is that it is following discussions with one of the representatives. I know that public health do show a very big interest in the time that alcohol is sold, but I just know it was following conversations with one of the representatives.
And that's now part of the operating schedule for the committee. But of course, they don't have to stick to that, do they? They could decide off sales could go on for longer if they so wish as part of their decision-making process.
The application was initially for on and off sales as detailed from 9 a.m. until 11 p.m. Sunday to Thursday, and Friday and Saturday 9 a.m. until midnight. So that was the initial application.
And that's why members can still look at the off sales, because it's just an amendment to the operating schedule, but not the application.
Yeah.
Thank you very much. That's all I needed to clarify. Thank you.
Thank you very much. That is actually very helpful clarification. It's something I know as members we weren't at all clear if the 11 o'clock that was appeared in the paper was a morning 11 a.m. or, as Leslie says, we're so used to it being 2300. So that's clear. Ian, you've got a question. Would you like to ask your question?
Yes, thank you. I'd just like to clarify what the where the ground floor and the lower ground floor of these premises actually sit. And I'm asking the question because I walked past the building yesterday, and it occurred to me that the lower ground floor might be slightly lower than one might otherwise expect. So it would be helpful to have an explanation of that, please.
Councillor Cuthbertson, I think that's maybe a question you need to ask the applicant after, if it isn't covered when they present the report. I've also been up to that site and walked past the building, and I know that there is a dentist on some of the upper floors. So yeah, I think if you ask the applicants that as part of your, when they present their report.
I'll do that, thank you.
Sorry, there are two Ians on my screen. If I wish you to ask a question, Councillor Cuthbertson, I will address you as Councillor Cuthbertson. I had actually called one of the representatives who had put their hand up, and I would like, who is also called Ian, though he spells it differently. So I will call upon Ian to ask his question of
Thank you. I would propose I spell my name correctly rather than differently, just a Scottish spelling. However, aside from that, it was more of a question on the back of Mr. Chalambidis' point about the off sales. And forgive me, but I'm slightly confused. When I read the application, the original application was from 0900 to 2300 for off sales. And my understanding is that that's been amended so that no off sales will take place between 0900 and 1100, therefore preventing early morning off sales purchases. And forgive me, but the comment made by Mr. Chalambidis was actually suggesting something slightly different. So I was just looking for clarification on that point.
Yeah, within the report, just sorry, I just need to put my glasses on now because I'm reading the report itself. Within the report, it says that the applicant has agreed to only selling alcohol for consumption off the premises between the hours of 900 and 1100. That's on page 8 of the report. So that, to me, that means they will. So to me, that means that they will only sell alcohol as an off sale from 9 a.m. until 11 a.m.
So their off sales is only going to happen for early morning drinkers between 0900 and 1100.
Yeah.
Thank you for that clarification.
Well, hopefully people might drink it later in the day once they've taken it home. But yes, they can only do it as an off sale between those hours. Is what the applicant has agreed to with a responsible authority.
Thank you, Leslie. This is obviously something we can explore more fully when the applicant makes their application. Rosie, have you got a question for the licensing officer?
No, I don't have a question, but if I can help clarify for Councillor Ian Cuthbertson regarding the layout of the building. The wine bar would actually be in the basement because we have 3 steps up and then we have the dentists, and then a further story up is, I believe, going to be offices.
Thank you very much, Rosie. That's very helpful. Are there any more questions for the licensing officer? Okay.
Chair,
sorry,
Chair, if I may. And again, this may be something for the applicant to clarify, but if I could just please check with the licensing officer. My understanding of the reading of the report is that the applicant has amended its application so that the off sales shall be between 9 AM and 11 AM each day. And as a result of that, a responsible authority has withdrawn its representation. Is that your understanding? Because Mr. Charanambidi seems to suggest that maybe that's no longer that they may be actually seeking different hours now in relation to their off sales. Can you just clarify your understanding, please, Leslie? I'm slightly confused.
Yeah, it's I mean, it's clear in the report that following negotiations with responsible authorities, the applicant has removed the request for live and recorded music and agreed to only selling alcohol for consumption off the premises between the hours of 9 AM and 11 AM. So yeah, I'm assuming that that's been an agreed modification of the application by the applicant with whichever responsible authority that was discussed with.
Thank you very much, Leslie. Do any members have any questions of the licensing officer? No? Right. We shall then move on to the applicant's case. I hope people will forgive me. It's so much easier to call people by their first names, and I will do that if you will forgive the informality. So can we ask Leo to make the case for the applicant, please?
Ma'am, yes, thank you very much. This is, of course, meant to be a discussion led by you. So informality is to be encouraged and lawyers are to be discouraged. So that said, Mum, I think it's really important to start here with the concept. First and foremost, the site that we're looking at has, as a matter of planning, always been envisaged as some form of restaurant, bar or hotel. As you and your colleagues and your legal advisor will know, Section 182 guidance at paragraphs 14.64 and 14.65 tells you that you're to seek, as far as possible, to maintain a proper integration between the planning and licensing regimes, albeit recognizing that they are similar but parallel schemes. And so proper integration effectively means that it's very odd for the council on one hand to say, we want this sort of entertainment hub and this sort of food-led and leisure activities in the heart of the community with one hat, and then with another hat to say no. There's a great deal of concern around inconsistent decision-making of the council. The other thing is, as has been alluded to by Leslie in her report, is that this application is very local in the sense that it takes full recognition of the environment it is in. You will see at page 18 of the agenda, in the application, it's described by Mr. Williams being on the lower ground floor in a self-contained building, which is just for commercial use. It will be a cafe, deli, wine bar and restaurant with on and off sales, mainly for local residents. And the building is a grade 2 listed building with planning consent. So there's full awareness of the nature of the building and the function it is to be put to. And again, at page 27 of the bundle, part M of the application form, it makes clear that it's not in a part of town which is an established route. And in fact, the customers will predominantly be estate residents. So the whole application and the concept is rooted in a recognition of being part of the local community, being geared towards your neighbours. And of course, if you want your neighbours to be your customers, good neighbourliness is really at the heart of your approach, because the last thing you want to do is to put off the very people that you expect to visit and patronise. No doubt you've also had regard to your own statement of licensing policy. Paragraph 1.6 quite rightly recognises the importance of the quality of life for local residents, something that the applicant recognises, but also bringing greater choice to residents. That would include, in my submission, giving people the choice to visit somewhere locally, particularly where so many of our areas are now becoming these residential deserts, with our local pubs and bars and restaurants effectively closed, so that we're all forced to travel to our oversaturated town centres. Paragraph 1.6 of your policy encourages more family-friendly premises where younger children can go with their families. This, of course, has been highlighted as a family-friendly venue. You've heard in the representation, or you've read in the representations, the way in which the premises proposes to interact with the residential home. Some of those residents have expressed the view that they'd be able to visit this premises with their family and give them an escape from that. And also, at paragraph 6.4 of your statement, you seek to encourage local businesses exactly like this. Through its policy, you will encourage the development of local businesses, recognising the benefits to the local community by supporting local enterprise to the benefit of those residents. So you recognise how important it is to have these local venues within the local community. And this is very much in keeping with paragraph 1.5 of the section 182 guidance, the second bullet point of which encourages you to support responsible businesses. And you can take comfort that this is indeed a responsible business for the following reasons. Firstly, your responsible authorities have reviewed this application, and your responsible authorities have no objection to this application. Paragraph 9.12 tells you that the statutory appointed experts are there because they know about crime and disorder, they know about public nuisance, they know about consumer safety, and if they were concerned, they would have made representations. The applicant has engaged with the police responsible authority and has agreed conditions. So the operating schedule has been discussed with your responsible authorities. They've made comments and fed back on it, and the conditions have been agreed. And those conditions are set out at page 39, which are in addition to the operating schedule. And you can see there the way in which the premises proposes to operate. Substantial food and non-alcoholic drinks to be available at all times. It's going to be fully food-led. There will be a minimum of 50 table covers at all times. The external area will be closed by 2100 hours. There will be a telephone available between local residents that request it and Mr. Williams. And in fact, I have a significant clip of emails where Mr. Williams has engaged with and discussed the application with all his neighbours, and you'll see there all the conditions that you'd expect regarding CCTV. A particular condition around racecourse day, because we know racecourse day can have an impact and a concern, and then full documentation and so on. So you've got that. Like everyone, when I read the report, I was very confused about the off sales. Having said that licensing shouldn't encourage the involvement of too many lawyers, I was quite surprised by that. It seems to me that if you're a genuine deli and cafe, the idea of going and getting your prosciutto, red wine, some ciabatta and so on to take home, it seems exceptionally odd that you can't do that after 11 o'clock. I'm going to have to say that in his keenness to work with the responsible authorities, Mr. Williams perhaps agreed too much. Briefly as an aside, and perhaps more directed to my fellow lawyer on this call than anyone else, as I see agreements with responsible authorities, they are no more than undertakings by the applicant to amend the operating schedule for the committee. They nonetheless do not bind the committee, though there is no authority on that and there are conflicting views. What I will say is, in the event that Mr. Williams is fortunate enough to get a license from you, my advice to him, and I'm going to do this publicly so that his neighbours can hear that, is to make a variation application. It would seem very, very odd for there to be a local deli and you not being able to take your wine and prosciutto home for your dinner party. And indeed, to Mr. Cyril's point, though we don't accept that there will be an adverse impact on street drinking and the like, the restriction perhaps more logically would be later in the day rather than, you know, to start later rather than earlier. So I see where he's coming from, though it does demonstrate why we need to have a careful view of licensing conditions in this way, though I don't expect it to be I will say no more of it on this and leave it for yourselves to settle or a variation at some stage in the future. A little bit about the operator. He is local to you. He previously operated the award-winning Rose and Crown in Sutton-on-Forest, which he turned around from a failing pub to a food-led bistro, which was listed as one of the top 5 places to visit in the AA Guide, and also commended by the Michelin Guide. And in fact, his chef, he was there in 2006 to 2013. His chef has gone on to become a Michelin-starred chef of his own. He then worked in-house as an advisor for a brewery for a while. He took some time off thereafter to travel, and then worked in Walthamstow, in Walthamstow Village, in another food-led venue, very similar to this, a kind of deli concept, working for the local community. And it's only on meeting his fiancée, deciding to move back to York for a settled existence. I understand that there may be wedding bells and children in the future and so on, that he was seeking an opportunity that would match the family lifestyle he is looking for, which is why this venue is so ideal. It's not a late night venue. It effectively operates within standard hours, if I can use that term, though I know we don't have them in licensing. And it's about being food-led, community-led, and engaged with that wider community. In terms of the representations, Ma'am, I see the fears. And I understand them. But of course, as your legal advisor will tell you, there is a difference between fears and facts and evidence. There must be something substantial upon which you can reach a conclusion that the likely effects are going to be adverse. The first comfort that you can take, of course, is that your responsible authorities do not share those fears. The other thing you can take comfort from is that the fears are not uniformly shared by the whole of the community. There is a large body of support, and in fact, even in the correspondence that Mr. Williams has sent me from the residents' associations he's been talking to, it's acknowledged that there are supporters as well as detractors. What you need to do is not look at the fears, but look at the operating schedule. What more could be done? Could anything further be done? And recognize that the decision you are making is not a decision that is being made in order to allay the fears of a vocal community, but of the wider public interest. And the nuance that comes from these representations is perhaps best observed in the representation by Sarah Pascott, which is at page 71. She writes on behalf of the Chocolate Works Care Village, and she says, as the manager in charge of this, how she supports the application. It's a breakaway space for her staff, for the residents, and indeed for the residents and their families. And over the page at page 73, you also have a representation from one of the relatives of the residents saying it's such a good idea to be able to visit a local place away from the residential home. No doubt your legal advisor has briefed you on your public sector equality duty. It strikes me as very interesting the way in which concerned individuals from the local community propose to speak for the elderly and say they need quiet, they need peace. I mean, I'm sure the manager is far more effective, and you need to have regard to age discrimination in all its forms. And so to assume that just by being of a certain age, the only thing you need are peace, quiet, and no options or facilities within your locality for entertainment, engagement with your family, and being able to go out is just the wrong view. And it also demonstrates the tenor of representations being made by well-meaning local residents that are nonetheless not professionals in the licensing field. So I'll say no more than that, other than to warn you that one must be aware of the personal subjective element made by these representations, and to bear in mind the test that you're no doubt familiar with, which is that they must be relevant to the licensing objectives rather than personal to the objector making the representations. So, Ma'am, it just leaves me to conclude by saying that Ben has the experience. He's engaged with local residents, he's engaged with your responsible authorities, he has the experience of operating community venues to the highest calibre to the benefit of the local community, and to commend the application to you in exactly the same way that the application is being commended to you by your responsible authorities. And I would ask you to grant it as applied for, and you're able to solve the riddle of the off sales in whichever way you and your colleagues see fit. Ma'am, thank you very much. I'm available to answer any questions. And of course, I have Mr. Williams here as well, if he needs to. He is WhatsApping me in the event that there is anything that I need to address. He has sent me a screenshot of his discussions with public health. It says, "Hi Ben, thank you for confirming the change in hours for on-trade sales to 11 AM. The licensing authority will update your operating schedule accordingly." Well, that's completely different to what is in the application as well. So I'm very confused. Well, I'm going to rely on the application as advertised. The responsible authority has withdrawn, and it's not clear upon what basis they've withdrawn. I very much leave it to you, Ma'am, which is a bit unfair. I think I've just passed the buck. I'm happy to discuss this more with all of you and Leslie, obviously, to get to the bottom of it. Thank you very much.
Thank you very much indeed. That's our job, is to have the buck passed to us, and we will deliberate and consider it in the light of all the representations. I'm going to ask Councillor Mason, I'm going to ask the representatives first if they've got any questions.
Sorry, just a quick question. This isn't my presentation, I presume.
It's Richard Jackson, Chair, Councillor Luckett. There you go, you've unmuted. There you go.
Sorry.
This isn't my actual representation, I presume. This is just to ask further questions.
This is just to ask a question. If you want to clarify anything that has been said by the applicant's representative, it's just to ask a question to get clear what they're saying. It isn't your actual representation, where you will have a separate slot to make it.
I remain very unclear about the sale of off-sales alcohol, and wanted to know whether, because it seemed quite clear from Leo's presentation that they may seek a variation in due course. And I just wondered, if they do seek a variation, who would be involved in decision-making about that, and whether representors would have an opportunity to make comment.
Absolutely. I just raise it more in the spirit of openness. I don't know if Mr. Williams is going to decide to do so. Just as someone who works in licensing, I thought it was very odd. And in the event that someone does make an application, particularly given the legislation has been relaxed to permit on sales, off sales on premises licenses in any event, he would have to make an application. He would have to put up a notice. You would all have to read it. You'd have 28 days and you can comment on it. So in licensing, a licensee can't change his or her license in any way without making an application and fully engaging with the local community.
Okay, thank you.
Chair, can I just interject 1 second, please? This is where I admit I don't write the committee, I don't write the hearing reports, but I've just gone onto the record and found the correspondence between my colleagues in public health and Ben, and from what is said in the email correspondence, Ben has agreed that between 9 a.m. and 11 a.m. they will only be doing off sales of alcohol, and on sales of alcohol will not start until 11 a.m. So they want to do off sales of alcohol for the whole time that they're open, but on sales of alcohol will not start until 11 a.m. Ben, am I reading correctly what you agreed with public health?
Yeah, that is what was good.
Yeah. So I apologise that isn't clear in the report, but as I say, sorry, I don't write the reports. They have my name on, but I don't write them. But it's in the email correspondence. Off sales of alcohol are from 9 a.m. until the close of play, as in 11 p.m. And then on sales of alcohol don't start until 11 a.m. in the morning.
Right. It's yes.
Sorry to confuse everybody. I really am.
I hope you are going to make things much clearer. We will, before we go into recess to make our decision, we will make sure we have this absolutely clarified. Rosie, I note your question. I've got Ian Cyril first, and I will call him first.
Chair, it's a question. It is a question to Mr. Charalambidis. And at the beginning, thank you for your presentation, but at the beginning I was slightly confused when you talked about section 182, and you talked about the proper integration of the original concept. And you talked about the original concept being a hotel or being other forms of entertainment premises. I'm slightly at odds with that and slightly confused by it, because my understanding is that may have been some kind of loose discussion, but certainly in the last 6 months, York City Council has made the planning application for that building under very strict conditions. But the planning application was for a coffee house deli, not to be open beyond 8 p.m. And that's what York City Council agreed to. So thereby fully accepting your potential conflict with the council being inconsistent from one department to another, I would just ask you to, if you could just clarify that, because that was my understanding.
No, so my understanding is that there is a full planning permission in place, and there is a limit on the hours for the outdoor base. Other than that, the hours applied for are consistent with planning. Mr. Williams, would you like to confirm that, please?
Yeah, as far as I'm aware, that the planning is for complete planning, and it is just the outside that's restricted. And that was in the last 6 months. The previous planning application was actually for a 3-storey restaurant, cocktail bar, and shop. So it has been approved for actually
Thank you very much.
much more than what it is.
Okay, does that help, Ian? Yeah. Okay, Rosie, you're next.
Thank you. I'm also confused because in the meeting that we had with Mr. Williams, with Ben, he was very, very clear that his whole concept was wine-led, and it would be wine and small plates, whereas his representative is suggesting it's food-led, and that wine would be an added extra perhaps. So is Mr. Williams knowledgeable about what he's doing, or is his lawyer interpreting it so that it looks more amenable to the committee? I'm not sure. And I would also add that the care home has its own alcohol license, and therefore, and has a bar and a cinema and so on and so forth. So they do have very good provision for their residents and visiting family. And I would finally say that most of the residents, in fact, all of the residents at the care home are in bed by 9 o'clock. So an 11 or 12 o'clock opening or closing time isn't really of interest to them. But I'd be very interested to hear the feedback.
So, Bob, there's a number of questions there. Firstly, if you turn to
your question, Rosie. Sorry, can I just clarify? We will stick to your question, Rosie, and leave the hours of when people go to bed as part of your representation.
Okay.
You asked a question whether it was wine-led or food-led. I don't know if Leah or Ben wish to clarify.
On page 33, you'll see on the plan just the size of the kitchen, which includes a wood-fired pizza oven. So of course it's food, it's a food-led. If you look at the application form itself that was filled in by Ben, you can see it's a wine bar restaurant on and off sales, mainly for the local residents. So it's always been food-led with wine. And as you're aware, food-led is a term of art used in the licensing regime to denote the style of a premises as opposed to a vertical drinking establishment. And just in case you needed further confirmation, you can see the condition 1 agreed with the police the premises will trade predominantly as a restaurant, cafe, deli, and substantial food and non-intoxicating drinks will be available at all time the premises are trading. And then condition 2 is that there'll be a minimum of 50 table covers at all times when the premises are trading. And that's the nature of the operation, and also demonstrates the nature of the discussion that Ben has had with the responsible authorities and the local residents in order to winnow out an application that meets everyone's needs.
Well, I have to respond to that by saying, as a local resident, and with good hearing, I was there alongside other local residents when Mr. Williams said very categorically it would be wine-led, not food-led. And he made the comment regarding small plates as though the food was an extra.
Well, what's absolutely wonderful, Ma'am, is that we're having this discussion. It's moved on. And what you have is a premises license that is conditioned to have substantial food available throughout the day. It has a substantial kitchen, a pizza oven, chefs, and so on. And it will not be a vertical drinking establishment.
Thank you very much for that. You can pick that up further, Rosie, if you wish to, when you make your representation. But that's the question, and it's been answered. Ian, do you have another question?
Forgive me. There was a second part to my original question, and again, it is a question for Mr. Charlambidis. During your presentation, you spoke about the fear that objectives may have about the fear of antisocial behaviour or the fear of nuisance, and I understand that. but also you spoke about how the responsible authorities, specifically the police, had not made any representations. However, I wonder if you would agree with me. They would not, as you put it, either accept fear. They would not. They would only base their objections on evidence. And there has been no evidence of antisocial behaviour in this area. There is no history of antisocial behaviour or nuisance within this largely residential area. So therefore, it would be unusual for the police to object, because that's the only grounds on which they can object.
So, Mum, there's two parts to answer that. Firstly, when I refer to sort of fear of outcomes, your legal advisor will tell you, and you're probably familiar, that I'm referring to the case of Daniel Thwaites, which gives us, it talks about having a suitable evidence base. The relevant evidence base in respect of a premises license is first and foremost its operating schedule, because that gives you an indication of how a premises will operate. So what the police are looking at on a new application, or indeed any of the responsible authorities, is how is it proposed to operate in this area? In other words, what will the operator do to secure the promotion of the licensing objectives? And so it is the operating schedule that is discussed, it's looked at, and from that you can assess the likely impacts. The responsible authorities are the statutory experts, and they are able to provide an alternative way of looking that isn't necessarily personal or subjective. And I'm not saying that the personal or subjective is wrong, but I am saying that your experts who have a wider approach in these matters are able to consider things in perhaps a way that is slightly removed from the personal.
Thank you very much. Yeah, I think that's... Sorry, go on, Ian.
Forgive me, my question was, would you agree that the police can only make their comments based on evidence? And that was my question. I'm not quite sure it was answered.
No, because the police make their submissions on the basis of meeting with Ben, looking at the operating schedule, looking at the area, looking at the likely effects. And so they won't just narrowly comment on whether there is antisocial behaviour or not in the area. It is a far wider exercise than one being proposed by Mr. Cyril.
Thank you very much indeed. Councillor Mason, you had a question.
Thank you. It might be one more for Ben Leo to pick up, but I suppose it's the kind of, the venue has a kind of all-encompassing all things to all people potential, I suppose, in terms of its description. How do you see that operating in real life? Can I come in at 10 o'clock and pick up some olives at night? Or is it, at what point will that kind of close? And looking at the floor plan, obviously I can see the bar's got kind of seats at it, so it kind of doesn't look like a kind of deli type counter bar with maybe a big glass screen. I just wondered how you feel it all kind of fitting together in terms of that deli restaurant.
So the discussion has been that you would be able to come in for breakfast, though it seems to be the case that you couldn't have a mimosa for your breakfast, but you'd be able to come in for breakfast. You would be able to come in for lunch. And then as the evening progressed, there would be sort of a greater focus on pizzas and food. The food will be able to be taken away. All of these tables can be moved, though the condition stipulates that there must be a minimum of 50 covers. So you could come in and get a charcuterie order to take away. You could order food to take away, and it's designed to be that sort of very flexible place. For example, I think something like Carluccio's. Ben, you gave me a really great example. I can't remember it. I think Carluccio's is perhaps the best example, where you can come in and dine, and you can equally take away food, and the business is split between that and people's local needs.
I suppose I kind of get where you're going, but in terms of physical space, I think, when you say deli, people have, I suppose, maybe a fixed idea of actually a fair amount of space given over to things being on display. Not pre-ordering, you just be able to go in and say, I'll have some of that cheese and some of that meat, and I'll take this bag of crisps and these crackers. Is that not what you're saying? It's more of a kind of pre-order of higher end things to take away?
I think it's a bit of both. Ben, can you answer this, please?
Yeah, it will be effectively both. So from the plan, you can see the kitchen on the sort of top left side, and towards the top right side, there's a storeroom, but there's a big gap between the kitchen and there. So that is earmarked for deli space. So it'll have shelving for olives and whatever else. Meats and cheeses will be kept on the kitchen side, which will be people will be able to come in and just buy them as you would in any deli. And then other movable shelves will be put in that middle space to create more of a shopping, sort of an upmarket shopping environment, I guess you'd probably say. To go alongside freshly baked cakes, breads, blah blah blah, in the actual restaurant itself.
I'd probably say half of your tables are in that kind of space. Is it something you're saying about it being movable? Is it something you think, well, at 9 o'clock I'll put it all away, or to create more table space? Obviously conscious you've obviously agreed to how many spaces you're going to have, but that looks like half of them in that kind of between the kitchen and that storeroom.
Well, not specifically, no, because the tables are just there in the sense that they can be moved around, so they can all be joined together. So, you get a lot of places where you get a big table of 8, but no one uses it. These will all be more like 2s that can be pushed together and moved around. So the space becomes a bit more flexible in terms of where everything can go. If people want a private meeting or something like that, it can be moved around. But
you probably get where I'm going. That basically is, we give you a license and it's a deli / restaurant, and actually we turn up and it's, all of that's vanished and there's more tables out. And I think if you're describing it as a deli, then there's a fair assumption that has a certain meaning. I think we can leave that for now. I suppose the other one I was thinking was around I think it was around timings. And in terms of that hot food offer, I don't think the police have actually conditioned that it's always got to be available until kind of 12 o'clock at night when you stop serving alcohol, say on a Friday. But have you got any idea of when you would stop serving food, or when you want to stop serving substantial food?
I mean, I think there'll be a substantial food offering constantly, because it's not that difficult, especially the colder items. But pizzas, I would envisage to be, as late as people want them in that sense. So
I'd be realistic, because the last thing you want us to do is to put a condition on that you've always got to serve, or food's always got to be available, if that isn't a realistic expectation. I don't mean to, sound like I'm teaching you to suck eggs, but we've had other applications recently talking about other issues around costs of keeping kitchens running during all trading hours. So I think be realistic. If you think you're not going to serve food after 10 o'clock, I wouldn't want us to put you in a position that isn't tradable also.
Yeah, I think there's a natural end to a food time, because people aren't going to go out at 10:30 for a pizza. And equally, kitchens need time to close down. And I don't want to be in the position where we're trading food right to the very end, and then it's going to be an hour of noise for them to clean the kitchen down and turn the fans off and whatever else. There has to be a sensible.
Again, Lee, I'm not prejudging anything, but I think that's quite important in terms of saying you're a food-led venue and what time that changes.
Well, so a food-led venue with these hours, if we look at the hours, the reality is, given that there's going to be a full pizza oven and a full kitchen, if we think about operating until 11 and then there's a half-hour closing up time, a pizza takes between 15 and 20 minutes to cook in the wood fire oven, and there is no application for late night refreshment. So the last hot food would be prepared at 10:30. The last sale of alcohol will be at 11, or will be at 12. So there will be a period where you will have eating up and drinking up time. For food, the cutoff will be service at just before 11, but then you can consume until close. For alcohol, it will be at 11. On Sunday, it will be later, because it will be 12. But from 11 until 12 on the Friday and Saturday, it would only be olives, charcuterie, and cold things that could be served after 11. So and the way the plan is set up would mean that, as you've heard from Mr. Williams, food will be available at all those times.
So you'd have no problem with a condition that said, the kitchen must be open and the last order for substantial food would be 10:30 or 11 o'clock.
On the information I have, no, but if Mr. Williams could confirm that.
I suppose you've just got a difficulty of when you're going to actually eat it. You're probably not going to.
I know, but you're offering a food-led venue, and you've obviously got concerns about that. So it's a condition that might well want to be explored. Maybe it's one you can think of for when you get to your final representations.
And so I think can I just the council's legal advisor Sandra has just raised her hand. Did you want to comment on this one, Sandra?
Yes, Chair, if I may. Can I maybe just remind members that on page 39 of the officer's report in Annex 3, the applicant has already agreed to amend its operating schedule with conditions relating to how the premises are going to trade, and that food will be available at all times the premises are trading. As a result of the applicant agreeing to amend its operating schedule, the police have withdrawn their representation.
Okay.
Thank you.
That's fine. That makes it really clear. Thank you.
And sorry, I thought I'd taken you to conditions 1 and 2, so apologies if that wasn't clear.
No, I think you had. Maybe I'd misread the. I know recently we've been dealing with things where actually, this has been a contentious issue around when does food stop, and we've been putting conditions on that are very specific about that.
Oh, I mean, yes, for the members of the public, we all have those applications where they offer substantial food, and that means a packet of crisps, and then they run out at 8 o'clock. This isn't what is happening here. And just also to clarify, there is a difference between the supply of the food and consumption, and that's not a licensable activity.
Thank you.
I think we've got a clarity on that. Councillor Cuthbertson, did you have a question you wanted to ask the applicant?
No, thank you, Janet. I think what has emerged is clear. Thank you. Thank you to both sides for clarifying that.
Right, before we move into the representors' opportunity, can I just get final clarification from perhaps Leslie? The hours that we are looking at are that there will be off sales from 9 a.m. to 11 p.m, but on sales of alcohol will not start until 11 a.m, so that you don't go in and get a double brandy with your scrambled eggs or whatever it is you're having for breakfast. But you will start to sell alcohol for consumption on the premises after 11 o'clock in the morning. But the off sales will be available, as you would expect, I suppose, from a deli all day. Am I clear? Is that what is being applied for, Leslie?
Yeah, on looking through the documents on the record, the off sales of alcohol have been applied for Sunday to Thursday, 9 a.m. until 11 p.m, Friday and Saturday, 9 a.m. until midnight, and on sales of alcohol following negotiations with our colleagues in public health, on sales of alcohol Sunday to Thursday, 11 a.m. until 11 p.m, and Friday and Saturday, 11 a.m. until midnight.
Thank you very much indeed. Right, Councillor Mason, can you withdraw your hand now? And I will move on to the representors who are now making their case. And you each get 15 minutes, and you each get an opportunity for people to ask questions. So I will look at them. You're put on my list as representator 1, 2, and 3. And I've now, yes. So I've got Rosie Preston down as representator number 1. So I'm calling you first. You have up to, but not more than, 15 minutes.
Thank you, Janet. First of all, can I say a general thank you for the opportunity to speak today. The liquor store, which would be home to the wine bar, is a lovely old building, which I'm sure everyone is pleased to see restored to its former glory. It sits in the middle of a residential area. There are 400 households, 400, to the rear of the liquor store, 40 of which, called Orange House, sit immediately to the liquor store's right, at approximately 10 metres away. Adjacent to this is the Chocolate Work Care Home with 90 residents. To the left of the liquor store is the Clock Tower with 22 apartments and again, about 10 metres away. And then approximately 25 metres in front of the liquor store is the former Terry's Chocolate Factory with 166 apartments. This could be deemed nothing other than a residential area. The demographic is mixed and includes couples, single people, those who are older and the vulnerable, young families with babies and toddlers, and others with school-aged children and young adults. Most of the children attend local nurseries and schools. The nature of the tall buildings in this residential area makes any noise amplify. Noise affecting residents is not something out of the ordinary for us. We've had the Chocolate Work construction over the last 5 years, and now to the rear of the site, we have the ongoing construction of the acquired brain injury clinic. However, it has been the lack of sleep we have struggled with that has come from the close proximity of the internal refurbishment of the liquor store by Gem Construction, particularly when they frequently began work at 6:30, 7 in the morning, instead of the permitted 8 AM start time. Ultimately, we had to ask both planning and public protection to enforce the 8 AM start. This is an instance of how disruptive the noise from the liquor store can be for residents. And I would add, with so many bedrooms of apartments facing onto the liquor store, there is a real problem regarding disrupted sleep for hundreds of residents. Bringing the liquor store back to life is to be applauded. When residents heard there was to be a coffee shop as part of the development, people were delighted, and that was the first application for a coffee shop. Many felt it would add to the social fabric of the community and would be an ideal place to meet friends and neighbours. Thereafter, we were told it was to be a restaurant with a 9 PM closing time. Again, good news. However, the application by Ben Williams of Ebor Holdings for a license to sell alcohol on Sundays to Thursdays until 11 PM and Fridays and Saturdays until midnight at what has evolved into a wine bar selling small plates of food was not good news. To put this in context, Bishopthorpe Road, which is a very popular high street that I'm sure we're all aware of, has restaurants such as Trinacria, Melton's and Rice Style. These close between 9 and 9:30, plus Angel on the Green and the new wine bar, which close at 10:30. This application is asking for a much later closing time and is smack bang in the middle of our residential area. Further, the actual closing time is likely to be even later, given users having drinking up time and staff needing to clear up. Another factor to consider is that those using the wine bar are unlikely to leave the premises quietly. They will not be tiptoeing out. Alcohol fuels loudness when people speak and can also lead to antisocial behaviour, which can in itself lead to disturbances for residents. Staying with residents' well-being, and in particular being woken by the noise of wine bar clients leaving the premises, research on potential sleep deprivation is widely available. For most adults...
Mom, I really need to interject and ask you to take advice from your legal advisor.
Indeed.
The whole point of making representations...
Can I just ask that I'm allowed to speak as you were without interruption, and that then you can ask questions?
Mom, there is a legal procedure which is not being followed. As you and your colleagues know, the hearing regulations require a representative to speak to their representation, This representation is number 23 in the bundle, and what we've heard already is way beyond that representation. So I'm going to really have to ask Miss Brannigan to just give some advice and provide some direction. And I appreciate that the local residents are not familiar that this is a legal regime, but there are rules that need to be followed, and to bring in data and information and talk way beyond the representation is wholly inappropriate, as you know. So please, if you could.
Thank you very much. Thank you very much. I will ask Sandra to just rule on this this point. Sandra.
Yes, Chair. It is the case that representatives are obliged to keep within the parameters of their representation. I think Mr. Charalambidis would agree that it is possible to elaborate and expand on the representation, but yes, they do have to stick to what is in their representation, essentially. That's quite correct. I'm
very grateful for that. And we've gone beyond elaboration and expansion into new areas. And of course, you'll have noticed that Ms. Presland is presuming to speak on behalf of a community, not herself. And I kept my hand down for as long as I could, but I'm really grateful for that guidance. Thank you.
Thank you very much. It's always helpful. Rosie, it is always tricky when you're dealing with legal processes, but we have had the advice. You do need to stick as far as you possibly can to the comments and the points you made in your original representation, which I'm sure you've got in front of you. And although I'm not asking you to just repeat it verbatim, I think we don't what is called introduce new evidence or new points that people haven't had an opportunity to think about and look at previously. So is there anything more you wish to add that is germane to your original representation? Am
I not permitted to talk about features like sleep deprivation and how I and my family have struggled with sleep because of the noise, and also the future noise that is likely to come from the clients of the liquor store come wine bar leaving? Is that not permitted? Am I going to be stopped speaking on something that is of real concern to so many people?
You are certainly entitled to raise the issue of your personal fears that the noise of the operation may cause difficulties with your personal sleep and your personal comfort. So
I can tell you that, sorry, I didn't hear the last part there, Janet, you were muted.
Have you got much more to add to your representation?
Yes, I want to talk about my sleep deprivation then, which has already occurred and which I anticipate continuing. And the probable 5 effects of sleep deprivation are increased risks of hypertension, diabetes, obesity, depression, heart attack and stroke. Also, I have friends on the site who have young children who are very, very worried about the possibility of sleep deprivation. And we also know that this can affect academic achievement, and that impaired sleep quality and quantity are associated with decreased learning ability and compromised daytime functioning. This is essentially a residential area, and the thought of people right outside our bedroom windows and very much in hearing distance are going to have carte blanche to leave, to make noise, to disrupt my sleep patterns, and that would happen 7 days of the week, 52 weeks of the year, and I'm not even talking about the extra difficulties of the 18 days of the race day programme. And I would ask that while I'm not asking for a refusal of the license, I am asking that we look at a 9 p.m. closing time. Of course, our community would benefit from having coffee shops and wine bars, and even though they are still led by wine and not food, but we would also disbenefit in terms of health by not having a proper closing time from the wine bar. I'm sorry I haven't been able to go through my whole presentation due to the lawyer's intervention, but there you go.
I think you've made a very eloquent case. I think we'll take on board all your representations. Do we have any questions for Rosie, either from the applicant or from any of the councillors? Councillor Cuthbertson.
Yes, thank you. Rosie, can I just clarify the distances that you specified between the premises involved in this application? First of all, the residence, secondly, Orange House, and also the care home. I'm looking in particular at the plan, which is on page 133 of the application pack. I take it from what you've said that your home is on the first or second floor of the residence, which is the long rectangular building at the lowest end of, I say lowest, but you know what I mean, geographically the lowest end, with it has a kind of a ring in the middle of it, and you're somewhere to the right of that, immediately facing the application site, which is hatched in black ink on my photocopy here. Now, if you could just outline to me where Orange House is and where the care home is in relation to that.
Okay, Ian. So first of all, I'm on the 4th floor and almost directly in front of the liquor store.
Yeah.
And certainly, you can hear a pin drop with ease because of the nature of the tall buildings.
Okay.
The Orange House, as you look at the liquor store, is to the right, and that's where we have. That's where we have 40 apartments. This is affordable housing with many children and young families there.
So that's the building.
To the left.
Excuse me. That's the building that looks like two buildings connected together.
Yes.
If I can put it, I'm not putting it very eloquently. Okay. So that's Orange House. And the building to the left of the liquor store
is the clock tower with 22 apartments.
Right. Okay.
And even within that, for example, the ground floor apartment has 2 babies in there, two children.
Okay. Was there any other building to which you were referring?
When I was talking about the care home is adjacent to Orange House.
Right. Okay. That's between the Orange House and Bishopthorpe Road.
Correct.
Right. Okay. Was there any other building that you referred to? I've got 3 there that I think.
Right. The buildings that I was referring to, the Chocolate Work Estate, is immediately behind the liquor store. It begins there and extends onto Campbellshire Road. There are 400 households there.
Okay. Fine. So that's Clock Tower Way, the bottom end of it. Is that right?
Yes, it would be, I think. Yes.
Okay.
Yeah.
Fine. I think I understand what you're talking about. I did take a trip up there yesterday afternoon when I was in the vicinity, and I did stroll around the area. So I've now identified what you're talking about. Thank you very much indeed.
Fine.
Thank you very much. Are there any other questions from anybody for Rosie? If not, I'll move on to Norma. It's your turn to make your representations. You have 15 minutes, and I do keep an eye on the clock. So thank you very much.
Okay, thank you very much. I'd first like to say that I support everything that Rosie presented, and I feel that she quite helpfully summarised the concerns of many of the people who've put in representations. So I think that was actually very helpful to this hearing. My own personal concerns are to do with noise disturbance and antisocial behaviour resulting from the sale of alcohol in the evenings in particular, and parking issues. I'm very concerned that the Chocolate Works, Clock Tower Way in particular, and the residents will become established routes to and from the liquor store. Just with respect to my neighbours from the residents, since the end of Clock Tower Way opened up, following the completion of most of the building work, it's evident, as I live here on Clock Tower Way, that there is a lot more traffic up and down Clock Tower Way, to and from now the co-op, to and from people taking their dogs for a walk down to the racecourse, just generally walking through the Chocolate Works development as a sort of new route. Obviously, the majority of that footfall is during the day, and it's people just going about their normal business. So from my perspective, that's acceptable. What I am concerned about and interested to note is that the applicant states that the premises are not in a town and not part of an established route. Well, I would contest that in terms of it becoming an established route, as I've already seen evidence, given now the Clock Tower Way is opened up to the residents, that we are seeing a lot more traffic up and down, pedestrians, etc. So I'm interested to know on what basis the applicant actually made that assumption that it's not an established route, because it is becoming more and more so, and I fear that this will become an issue, particularly with people leaving the premises of the liquor store late in the evening, and obviously as people are concerned about having had a good time, still wanting to relive that. The other thing that I'm concerned about is that this aspect of it being a local function venue, as I'm not aware that I was particularly consulted about the use of it. And like Rosie, I think there are many people who live here on these combined developments who would not see it as a local venue for us. So I'm sort of interested to know on what basis the applicant has made that assumption that it will be predominantly for local use, because I don't see any evidence that that piece of work has been undertaken. I suppose the other thing that I've studied the floor plan of the liquor store. I've obviously read lots of the representations, etc., and it's unclear to me just how many table covers in actual fact the liquor store will be offering. I note that there is a minimum of 50, but if I've added up all the little dots that represent chairs on the plan, I come to 60 table covers inside and 28 table covers outside, which to me suggests quite a big establishment or venue, and particularly with the hours being stated for completion of food and drink and allowing for drinking up time. That seems to me to be quite a large volume of people either exiting via Clock Tower Way or picking up their car or taxi within the residence. The final point on the issue of noise disturbance and unsocial behaviour that I would like to comment before moving on to parking is to do with whether there is provision or not for an external smoking area, because obviously for people who are very close to the liquor store, this will add further noise nuisance and potential for antisocial behaviour, as well as the impact of cigarette smoke. So those are my concerns in more detail about the noise disturbance and unsocial behaviour that I believe will I will use the word inevitable, because I think that, in my personal opinion, that is what it will be, that residents of the combined communities and developments around here will be subjected to. I just want to move on to parking, and a concern that visitor parking spaces in both the residence and the chocolate works will be abused by people who choose to drive to the liquor store. The other thing that I'm unclear about, from having looked at, well, I've looked at the plan and I can't see the designated parking spaces for the liquor store, but in reading the various correspondence and documents, I've seen quotes of various different numbers of parking spaces allocated to the liquor store as a sort of entity. And I'm interested to know how many parking spaces are allocated to the liquor store for the wine bar and delicatessen, because it's not clear to me. I've seen as many as 10 in total parking spaces quoted, and as few as 3 being allocated to the liquor store. And from my perspective, if there are only 3 parking spaces for a potential of 88 covers, that seems rather inadequate. I accept people may walk or use public transport to get to the liquor store, but even with that volume of people, I cannot believe that that won't have some impact on the people who live locally. I did specifically ask in my representation what signage would the liquor store be showing to say where people should park and what the arrangements are for parking, as it's clear that the number of parking spaces will be relatively limited, and to advise people using the liquor store not that visitor parking within the developments on either side and not for the use of their customers. And that's the end of my presentation.
Thank you very much, Norma. That was very helpful and very succinct. Does the applicant have any questions for Norma?
Mum, thank you. No questions. Mum, you're on mute. You're on mute, Mum.
Sorry. Do any of the councillors have any questions for Norma? Councillor Cuthbertson.
Yeah, thank you, Janet. Thank you, Norma, for your presentation. Can I check with you 2 or 3 perhaps small points? First of all, where is the parking allocated for the residents?
For the visitors? Or for the, well,
I'm looking at the plan at are you looking at the document pack, page 133?
I'm not, but I have looked at that plan.
Right, okay. Well, as far as I'm aware of it, the residence is a large building to the bottom, the south end of the site.
That's right.
But I don't know, but I didn't identify any particular parking spaces when I walked around the bottom end of Clock Tower Way and what is it called, Berry Mews and Banks Drive and Roberts Street, and I can't work out what the name of the other street is there. I didn't see any parking on the north side of the residence. So can I ask where you would locate the private parking for the residents, please?
Well, my question specifically was, where are the parking spaces for the liquor store?
No, can you answer my question, please?
Oh, right.
Which is, where is the private parking for the residents? The reason is you said that would be abused.
What I was asking, maybe I wasn't clear enough, within, as I understand it, the residents and the chocolate works, we have a number of spaces that are allocated for visitors to people who live on those two developments.
Yeah,
and there
I'm
are
going to ask you about that in a moment. What I'm asking you about is I believe there is an area of parking space allocated to the residents. And I wonder if you could just point out to me where it is.
I actually don't live on the residence, so
No.
possibly Rosie or Ian.
I think Ian is disposed to answer your question, Councillor Cuthbertson.
I'll be
Sandra,
pleased if
did
you
you
would.
want to make a comment?
Well, Chair, if I may, just in case it assists with the running of the hearing, is that whilst concerns about abuse of customers abusing the visitor parking is referred to in the representation. And of course, while this may of course be of concern to residents, I must advise the panel that parking arrangements are not, or abuse of resident parking, it is not within the remit of the licensing authority. I'm afraid that is a sort of a management matter for the development, but that is not a consideration for this hearing.
If I may point out, my question is related to the issue of traffic levels in the vicinity of the liquor store. And the residence's private parking was mentioned in that connection. Now, I believe it's likely to be on the south side of the residence, and perhaps Mr. Cyril will confirm that or not. Because I've then got another question for Norma, if I may, please.
Can you just answer that one, Ian, very briefly?
Councillor, if you look at your map, as you've described it, the residence, you have substantial parking to the south of the residence, but you also have a row of parking that butts up to the residence. And then between the residence and the liquor store, there are two rows of parking, one that butts up to the residence and one that butts up to the liquor store, if you like, and Orange House. And immediately outside the liquor store and running right in front of Orange House are 10 spaces, and those 10 spaces are shared for the occupants of the liquor store. The applicant has 3, and each of the other premises also have, and the view is that perhaps they'll be shared.
Right. So if I can just pursue that for a moment, the bulk of the access to the parking for the residents is on the south side of the residence. Is that true? It's the side away from the development.
That's correct.
If you're looking at the volume of parking, yes, the majority of the parking spaces for the residents is on the south side. Yes, the row in front is limited.
Okay.
Okay. Can we agree that one's been clarified as far as we need to clarify it? Councillor Cuthbertson, you had another question for Norma.
I'll keep it brief, Chair.
Please do.
As I understand it, most of the other parking spaces, particularly along Clock Tower Way and along the street which leads towards Bishopthorpe Road from Clock Tower Way and behind the liquor store, I don't know what that's called, but those spaces are mainly earmarked for specific dwellings.
That's correct.
Right, okay. And there's a limited, sorry.
Within Clock Tower Way and within the Orange House car park, there are designated visitor parking spaces.
Yes, and those might have a V on them, or might have a board which says designated for visitors.
Yes.
Is that right?
Yeah.
Yes, okay.
Yes.
Thank you very much. That's very helpful.
Thank you.
Thank you very much, Councillor Cuthbertson. Thank you, Norma. Are there any more questions for Norma? If not, I'll move on to Ian as the final representative. You have 15 minutes, Ian, to make your representation.
Well, thank you, and I'll hopefully be within that. I'll stick to the 3 representations, the 3 main points that I made in my representation, which are around the disturbance to the residential community, the potential for antisocial behaviour, but then also the actual process itself that has seen this building come to, or this application come before us now. You'll have noticed when we speak about the disturbance to the residential community, of the 82 or the 41 submissions, one of which included a petition of 52 objections. The vast majority do support the idea of this building being used for some use. The original plan was that it would be a coffee shop and a deli, and that was supported. And I know that the Residents Management Committee were consulted by York City Planning in the during that application and supported use for those purposes up to 8 p.m. The majority of the application, or the majority of the correspondence that I've read through that you have in your bundle also supports that. Of the objections that I've noted, having gone through the objections, and I note that Mr. Charmant-Leedis suggested there was a large body of support. Beyond the care home, I see little support. 3 people do voice support, but they don't live here. One lives in Bishop Wilton, some 13 miles away. 2 others live in South Bank in Trafalgar Street and perhaps are closer to the Knavesmire pub than they would be to this pub. Of the care home, I accept the care home. It is a useful premises as a coffee house, as a place to go, perhaps as you might read into the support that the care home manager gives, as an extended staff room for their staff. I accept that. But to a point equally, one of the people, the clients of the care home, suggested it would be a useful place to take their relative. And again, accepted. It's unlikely though that these people will be affected by the noise beyond 8 p.m. at night. So of those 11 pieces of support that Mr. Charmant-Leedis talks of, there's only 4 who actually support this without amendment. And that's 4 representations of support. 82 people object to the current application in its current terms. And it's all based on that disturbance in the community. Many of the people have talked about the amplification of noise, and I know Rosie's mentioned that, and Norma has as well. It is quite remarkable to be here and to hear the noise. You can hear discussions on balconies 50 metres away without difficulty, and these are not raised voices. The noise echoes and reverberates along the design of this residential area. It may help to know that on the 1st of October, the dentist, which is the level above the proposed wine bar, held an open evening, a celebration to celebrate the fact that they'd opened for business, and invited lots of people, and clearly it was clear to see there was a celebration taking place. It finished at 9 p.m. However, I sit in my premises less than 50 metres away, and the noise was noticeable to the point whereby watching TV, I was aware of a party happening outside, and it was only then when I investigated I realised what it was. That noise does reverberate and it does cause that disturbance. I raised a question with Council about the responsible authorities, and I do take issue with that. That your responsible authorities can only report based on the evidence they have. The police can only report on antisocial behaviour based on a history of antisocial behaviour in the area. There is no such history because this is a residential area, a carefully designed and approved residential area as went through the planning processes of this being a Grade 2 listed building by York City Council over a number of years ago. To then place a bar right in the middle of this risks inviting antisocial behaviour. Under the 3rd objective, it certainly will create nuisance, whether that be through noise, intentional or otherwise, because I do accept that the intention is for this to be an upmarket establishment, and I understand that. However, alcohol doesn't know social class. People affected by alcohol are naturally loud. I have 30 years worth of experience of dealing with antisocial behaviour. I am experienced enough and competent enough to say that in all of my years of experience, alcohol does not know bounds in terms of social class and in terms of noise. As I close, my point here is one to echo that made by many people. We supported the idea of a coffee shop. We support the idea of a licensed coffee shop, but to a certain point at the time of night, purely because of that disturbance. And my application, if I may, is that we look at this and we consider how we can walk before we try and run. I think the danger here is that we end up running before we've established whether we're indeed able to walk. And I would just merely invite councillors through this application to go back and revisit the original planning application made through York City Council and look at section 182 and ensure that proper integration takes place and there isn't an inconsistency in terms of York City Council approving a license for something which was inhibited by a planning application only 6 months ago. And
Thank you very much, Ian. That was beautifully focused. Do we have any questions from the applicant for Ian?
Ma'am, thank you. No questions from me.
Do any of the councillors have any questions for Ian? Ian, Councillor Cuthbertson. Not yes.
Sorry, Janet, that was a negative.
I've appreciated that, Select. Right, I think that then concludes the representations from the representors. The representors individually have 5 minutes in which they, if they wish to add any further, not any new evidence, no, I take the point, but if they wish to just focus their representation as a summary, Rosie, you have 5 minutes if you wish to take advantage of emphasizing anything you made in your presentation. Can you unmute yourself?
Apologies. Thank you, Janet. I would simply reiterate that this is a residential community with many, many hundreds of people here. And while we absolutely welcome the use, the good use, the healthy use, the social use of the liquor store, as it was going to be with, as Ian has just said, with a particular 8-9 p.m. closing time, we welcome it. It would be fantastic. But if it goes on until 11 or 12 o'clock in the evening and later by the time people actually leave, and we're talking, as a previous speaker said, we're talking about many people coming, not people just from this area, then we are at risk, for those of us who live here, of having a life sentence whereby we cannot sleep, we have disrupted sleep, and it would have health implications for all of us at a time in society when we are more and more aware of both physical and mental difficulties in people, particularly in our case, when sleep is deprived due to a commercial enterprise, which we support, but which must take into consideration our needs as well.
Thank you very much, Rosie. Norma, did you have anything you wanted to add by way of a summary? Not add, sorry. Did you want to emphasize anything?
I think it's not about licensing for alcohol per se. It's about limiting that to something that is appropriate and acceptable for this community. I still am unsure about the extent to which this community as a whole will actually use the facility. I think emphasis has been put on by the applicant that it will be a local facility, and I don't see any evidence to support that. I remain unsure about the impact and concerned about the impact, because the facility, if I have looked at the plan correctly, is quite large. It's quite a large entertainment facility. So that I'm not reassured that won't be an issue. Sorry, I was just going to say one final thing, and actually I've just forgotten what it was now. Just going back to something, one of the points one of the councillors earlier was making, having heard the applicant's description of the use of the liquor store, I was somewhat dismayed that it won't serve as what I would envisage as a traditional delicatessen, as well as offering you the opportunity to actually sit and enjoy the products and wine actually at the venue. I see it more from the way it has been described to me as being a facility that is not a delicatessen, that is to encourage, whether it's food-led or wine-led. My interpretation, coming away from listening to everything that's been said, is that it will be more wine-led than food-led. And that adds further concern to me in terms of noise, antisocial behaviour, etc., etc. So that's all I'd like to say.
Thank you very much, Norma. Ian, did you want to just sum up anything?
I think if I may, just to summarise and just to avoid the confusion and distraction that we encountered initially about the off sales. Just to surmise, Ma'am, there are only 4 pieces of support for this application in your bundle in its current form. Beyond that, the support is quite wide, but it's limited to the hours with the early evening closing. There's only 4 letters of support for in its full terms. As we mentioned, there is no history of antisocial behaviour. There's no history of nuisance in this area, and those are 2 of the 4 objectives that you must consider under the Licensing Act. But my question is, why invite that? Why risk the community and the peace of the community by potentially inviting that nuisance and the potential of inviting antisocial behaviour? As I mentioned, alcohol or the influence of alcohol knows no social bounds, and people will be loud, and taxis will arrive, and nuisance will be occurred as a result of the consumption of alcohol late night opening of these premises. As I mentioned before, for me, it's about walking before we run. Everybody supports the idea of the coffee shop. Everybody supports the idea of the deli, and perhaps we should explore that first and look at walking before we run. Because one of the things that hasn't been mentioned here, which I think should be a consideration, is the applicant himself. The applicant is a likeable, congenial individual. He's experienced. He's experienced enough to know that he's about to commit a substantial amount of money into this premises. And if the license, my concern, genuine concern, is if the license is granted as it stands, and there's a substantial body of concern that over the next 6 to 12 months, that means under review that license is subsequently revoked or withdrawn, the applicant risks losing quite a bit of money, which I'm sure must be a consideration for him. But the outcome is what happens in 12 months' time if this business struggles. Chair, I'll close on that.
Thank you very much. I think you were verging on the area of, I don't know quite, yeah, not going a little bit further than we're really meant to. Leo, as for the applicant, can you give us your brief summary and focus?
Ma'am, yes, thank you. Focus is a very good word. It's very easy in these kind of hearings to hear from local residents who are unfamiliar with the licensing regime, who are unfamiliar with the legal framework, set out their fears, their passions and their concerns. As you know, they need to be filtered through the issue of relevance, and relevance is a technical legal term. For example, your legal advisor intervened to talk about traffic and how people get to and from premises. Of course, it's not going to be relevant. You can't tell me how I leave my house and then travel to whichever venue. The focus, the inflexible focus on what they see and what they understand is unhelpful. So, for example, they failed to move or engage when the condition 1 clearly states the premises will trade predominantly as a restaurant / cafe / deli, and substantial food and non-intoxicating drinks shall be available at all times the premises are trading. That's been agreed with your responsible authorities. So to have submissions around wine bars and other matters is just unhelpful. Also, it's not about a popularity contest. It's not about counting how many reps are in favour and how many reps are against. It's about examining the operating schedule and, as has been done by your responsible authorities, and assessing whether that could promote the licensing objectives. All of your responsible authorities, environmental health, public health, the police and trading standards, agree that the hours are appropriate and proportionate. And they agree they are proportionate and appropriate because, as a matter of planning, your council has already determined that this local area would be served by a food and beverages venue operating at these hours. It is entirely appropriate for it to be in this location. And in fact, the original plan were for 3 floors of restaurants and wine bars. Otherwise, you find yourselves in this residential graveyard of nothing but premises upon premises upon premises. And so proper integration encourages joined up thinking, which is to support this application. Ma'am, your decision has been made in the wider public interest, not in the interest of the vocal minority. As sympathetic and as eloquent as they might have been, there is a premises application that has been reviewed, that is being commended to you, and I also commend the application to you as amended with all the conditions agreed. Thank you very much.
Thank you very much indeed. Before we close the hearing, do any of the councillors have any further points they wish to clarify before we move into our decision-making mode? None from Councillor Mason.
Not from me,
Councillor
Chair, thank you.
Cuthbertson, is there anything?
Nothing from me,
No.
thank you.
Thank you very much. I think then that we have had a very full presentation, very full examination of the application, and very full representation from those residents who wish to object to it. So I would like to thank you all very much for that. The public part of the hearing will be now closing, and we will reconvene as a subcommittee to consider what our decision is going to be. We will not be coming back into public session as we used to do when we met in person. And we will be notifying everybody in due course as to our
Councillor, you're muted or frozen.
I think she's frozen, Leah.
Ah, I think she was telling us that you'll give us a decision within 5 working days.
Yes, I think that's exactly what she was going to say.
Yeah.
Yeah.
I think
just to clarify, the normal order is that members will this meeting will close and members will meet in private to determine the application, and as Leo says, a decision will be published within 5 working days.
Thank you all very much.
Are we happy to close the hearing, Sandra, on that?
If members could stay on this call, please, and everybody else leave, and I think that's what we'd normally do, Leslie. So sorry, speaking for Richard because he's not around at the moment.
Thank you very much.
Thank
you, everybody.
Thanks, it's Richard here. I'll now end the live stream. Thanks.